This video is brought to you by Law Excellence IAS Academy.
Dear students, good morning. Welcome to DEEP, Daily Editorial Enrichment Program of Law Excellence R&D. Let us start the discussion on today's newspaper, that is 10th August 2019. The first article for discussion, Incisive Interventions that Blunt the RTI's Edge. So the Right to Information Act, it was a missing link among the Bill of Rights in India. Though it has come up as a statutory right, the Supreme Court of India has clearly stated that the Right to Information Act is intrinsic to right to freedom of speech and expression under Article 19(1)(a). This judgment is famous in PUCL versus Union of India case in 2004. Let us understand further about RTI. RTI is an instrument that has empowered the people. How did it do so? You know, information is power. Whoever possesses the information, they are powerful. So, bureaucracy is powerful because it possesses the information about you and me. In this case, RTI is an instrument to transfer this power from the bureaucracy to the citizens. That is the first thing. And then information is also great leveler. It means that information available to the citizens exposes them to the opportunities everywhere. And RTI Act also ensured accountability in the governance. It has exposed the mistakes, inefficiencies, diversion of funds, corruption in the government. In this context, let us understand mechanism how RTI functions. In every office, in every public authority, there has to be an officer called Public Information Officer. A citizen can go and ask for this Public Information Officer about any information he seeks to have unless it is excluded from RTI. So then this information has to be provided within 30 days. If he fails to provide for the information, the matter can be appealed before the Information Commission. For this, State Information Commission, Central Information Commission exists. These two information commissions, they shall have independence, autonomy, so that they can be free from the government and can ask fearlessly information from the government. So, the present amendment acts of the government are hitting directly on the autonomy of these information commissions. Let me make you understand this. Any autonomy or independence to authorities like this, it comes from the freedom from any interventions of the government. So, the government shall not be able to create pain if they go against the government. So how the pain can be created? Either by removing them from the office or reducing their salaries, etc. So this is what the executive did now. Previously, they had a fixed tenure of 5 years. And the second, they cannot be removed before this term, and their salaries and emoluments, they are equivalent to election commissioners and CEC. The Chief Information Commissioners is equivalent to CEC, and other Information Commissioners is equivalent to Election Commissioners. Now, these will be decided by executive. So, the government of the day, while they are being appointed, they will be decided from time to time. It means that if the government do not like them, they can be removed at the will of the government. And the second, the CEC and Election Commissioners' salaries can be reduced by the government, Information Commissioners and other Chief Information Commissioners' salaries can be reduced by the government at its will. So it is compromising on the independence of these institutions. The next is not the final word from Islamabad and Delhi. Now Kulbhushan Jad case, it was politicized, and both the countries, they are in a position not to go back on their stated stands. The golden mean to solve the problem, they were not in a position to find. Let us understand clearly. Mr. Kulbhushan Jad, he was stated as a spy of India and arrested in Iran and shifted to Pakistan. The charges of espionage, terrorism were placed on him, and life sentence was imposed on him. In this context, the military court is the one which has imposed the life sentence, death sentence to him. And there is no fair trial. There is a forced confession from him. Based on this forced confession, a death sentence was given to him. And the second thing is, Normally, if a citizen of one country, if he is arrested in the other country, then the consul need to be informed immediately, and he has to be provided with necessary legal access. This is what is called unimpeded access to the consul or consular access. This is what is stated by Vienna Convention on Consular Relations. So in this case, there are two things. One is fair trial. The second one is remedy. The fair trial means he has to be provided with a lawyer, unimpeded access to the consular, the particular Indian consulate, and in this context, forcing him to give a confession, a video confession, based on this awarding death sentence, it goes to very philosophy against the very philosophy of human rights. Now here, in this case, the fair trial is provided under International Covenant on Civil and Political Rights. So here, the International Court of Justice, it wants to see the matter only on the basis of consular relations. It do not want to see it from a human rights dimension under International Covenant on Civil and Political Rights. That's why it has clearly stated that the consular access has to be given, unimpeded consular access has to be given to India for Kulbhushan Jad. Next is with regard to remedy. So it is given by a military court. There is no fair trial. There is coercive confession taken from him. In this context, what India is asking, as it is not a fair trial, it has to be set aside and he has to be released. Now, what International Court of Justice has said, yes, there has to be effective review and reconsideration. So the military court's verdict, who has to review and reconsider, it is by the civil courts. Now in this context, to review and reconsider either by the highest executive or by the highest court of the land, there has to be some procedure established. Unluckily in Pakistan, there is no such a procedure. In this context, Pakistan has to pass a special law for this purpose. And anything if Pakistan does that way, it will be seen as a defeat by the Pakistan. It gets politicized. This is what happens when sensitive issues in international arena gets politicized. The triumphalism, chest thumping shall be avoided, and backdoor channels and trying to pacify each other and depoliticizing the issue, this can provide life to Mr. Kulbhushan Jad. That is what this article's essence is. The next is State of the Union. So this is about Jammu and Kashmir. Now, Jammu and Kashmir is on a shutdown and on a tight leash. And the sentiments of the Jammu and Kashmir are deeply hurt because they were never consulted on Article 370, 35A or downgrading it from a state to a union territory. So in this scenario, the Prime Minister's speech yesterday was a bit reassuring. What he stated is, Jammu and Kashmir's status as a state will be restored immediately, elections will be held immediately, and the third thing what he stated is, the development can be provided them on a swift pace. He has encouraged people to establish industries in Kashmir and provide tourism in Kashmir. So in this scenario, remember one point, economic development or material benefits offered to the people cannot be a replacement for the political freedoms, democratic participation, dialogue and contestation which has to be provided to them. So that's the reason why these political phase or political liberties and democracy, elections have to be restored to the people immediately. Next is taking on the mob. This article is about hate crimes. So you remember 2 points, Rajasthan and Manipur. These are the two states that have a law on the hate crimes. And the second, Supreme Court of India also has clearly stated that any kind of hate crime has to be dealt swiftly. In this case, in every district, there has to be a special officer notified for this, and district police officer shall act as a coordinator. And keeping all these provisions, Rajasthan has passed a law against mob lynching. In this case, it has clearly defined what is a mob lynching or protection from lynching bill. In this, lynching is been defined as this way. Any act of violence, whether spontaneous or planned by a mob on the grounds of religion, race, caste, sex, place of birth, language, dietary practices, sexual orientation, political affiliation, or ethnicity. All these can be constituted as lynching. If any two persons participates in that violence, that comes under the mob lynching. So in this case, this law can provide for certain deterrence, and this law also can be extended to Kap Panchayats and orders of killing issued by these Kap Panchayats. The punishment can go up to death sentence if the people have ordered for illegal killing of young couple for violating the caste and Gotra norms. So that's why it will be now again proportionality is the issue. Whatever the fine or punishment offered by a law has to go through this test of proportionality. Is the life sentence given for Kap Panchayat members or for mob lynching, will it come under the rarest of the rare cases to be given life sentence? That's what will be verified by the judiciary in this law. Next is, in Bede, a harvest of crushed hopes. Just to see, poverty, disease, ill health, all these will go hand in hand. In this district, Bede in Maharashtra, the number of hysterectomies have increased remarkably. The reason is most of these women work in sugarcane fields as crop cutters. In this context, menstrual cycle, pain, and other gynecological problems associated with has made them to go through a easy solution that is called hysterectomy. And hysterectomy creates lots of problems, medical problems after it. Now most of these women are suffering from arthritis, osteoporosis, like these diseases. In this context, the doctors and ethical medical practices, these need to be stressed in. And finally, thank you very much. Have a great day. All the best.